All rise. Division 1 Court of Appeals now in session.
Morning. You may be seated. We are here on our case number 1CA-SA180054, Juan Velazquez versus McCoy. Counsel, as you know, each side's allotted 20 minutes for your argument. The petitioner may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if when you approach the podium, both of you, or all of you, if you would give us your name and the name of your client for the recording. We have reviewed at length the filings, the petition, the response, reply, and the various appendices. We've also discussed the case in our conference this morning. So with that, you may proceed.
Good morning. My name is Tamara Birch-Primera, and I'm here with my co-counsel Emily Skinner on behalf of the petitioner Juan Velazquez. We brought this special action because in this capital case, we believe that the transcripts that provided and used on the direct appeal are substantially inaccurate when compared to the video recordings of the trial. In coming to that conclusion, we determined it based upon a review of those FTRs, which are an actual verbatim record of everything that happened. As we made that evaluation, we determined that as we investigated Mr. Velazquez's claims, that we needed to have an accurate record under due process, under fairness, and under the criminal rules. It's important that when we talk about what the errors are that we're raising, we talked about substantial errors. Rule 30A1, which refers to the Arizona Manual of Transcript Procedures, uses the word major errors as they define what an error is in a transcript. We use the word substantial and major the same. We are not talking about errors such as the and a pause, such as I'm sure I'll do here in this oral argument. We're talking about items that change the meaning of what was said, items that are omitted from the transcripts, things that actually affect what we do as the attorneys investigating Mr. Velazquez's PCR.
Here's the thing. There's some disagreements about what happens if and after errors are identified and a retranscription might be obtained. But before then, we've looked hard in the record for where the petitioner has identified to Judge McCoy, or actually to us, where errors have occurred. I'll just say it seems not fruitful for a petitioner to simply say, I think there's errors, so give me a whole new transcript. Perhaps the burden should be on the petitioner to say, I've looked at the FTR and here are specific errors. You've identified a host of them in the closing argument. It seems as if you've identified an error in the identification of an exhibit or a sample number in the DNA expert's testimony. What other evidence have you shown, or not evidence, a demonstration have you shown that there are errors elsewhere?
Your Honor, that is one of the problems with the respondent and why we filed this motion essentially 3 times. If you look at the transcript of the ex parte hearing, which we had with Judge McCoy on February 21st of 2017, you'll see that Judge McCoy tells us, I recognize that these errors exist. You as counsel are telling me that they're significant, and because you are telling me that, let's talk about what I'm going to give you. I'm not inclined to give you the whole thing. I am inclined to give that to you. He accepted our representation as attorneys that these errors are more pervasive. For your purposes, however, and since that is certainly a question, I have 19 different examples for you today. I can talk about 19 transcripts. We don't have time, but really quickly, we have identified, just for purposes of this hearing, 9 dates with substantive errors. For example, August 11th are the openings. This is all 2004 when the trial occurred.
Counsel, is this in your petition?
It's not in our petition because one of the problems with the respondent is we're limited to the record below, and the respondent accepted on the 21st our avowals, if you read that transcript, what it is that we maintained about the transcripts, and then he would never give us another opportunity.
I didn't read that transcript as accepting the avowals for all purposes for all time. I heard him to say, with respect to the specific items you had discussed, him accepting you as an officer of the court at your word.
Right. And if you recall, in that transcript, he also talked about how, what are some fruitful areas? The experts. He talked about openings. He talked about voir dire. And, in fact, the transcripts that I could identify for you today are exactly those type of things. On the 12th of August, it's Dr. Van, who is the emergency room physician who was the first one to see one of the victims. We have same thing with the DNA expert on September 13th of 2004, which is one of the mental health persons that we talked about with Judge McCoy, was Dr. Potts, who was the main witness in support of the mitigation. Additionally, one of the main witnesses against Mr. We didn't actually talk about civilian witnesses with Judge McCoy, but one of the main witnesses was a woman by the name of Eva Sandoval, and she is one of the other specifically identified transcripts that I have today. And what's interesting about these transcripts is that 3 of the transcripts that we can identify today, which is August 12th, August 16th, and September 13th, all 3 of those were at one point corrected by Michael Babicki, and a secondary transcript was filed. Even the corrected transcript is substantially inconsistent and incorrect.
Counsel,
from
are
the
these
FTR.
corrections that you have, or errors that you have identified in between the time of filing your petition and today?
Well, we haven't filed our petition. We have not filed our petition. These are items.
Petition for special action.
For special action, the thing that we're here for.
These are things that we've known all along, and
Okay,
that
and
had
you didn't include these 19 things in your petition for special action?
We didn't, because it's our belief that we are held to the record from the trial court, and since we are held to the record from the trial court, Judge McCoy would never let us back in front of him so we could talk about whether or not there were other explanations or other information that he wanted. The only indication we ever got from the respondent was that he believed that Rule 30 didn't apply and that he didn't have the authority to order these transcripts. With respect, the only thing that suggested a materiality type of decision on his part was the word compelling. But if you look at that March 2nd, 2017 minute entry, he's actually talking about the appellate claims, which is what he's at no point does he ever tell us that the overall transcript issue is not, we haven't created a sufficient showing. And so that's why we filed a motion to reconsider to disabuse any notions of other things. And we've also, even though we didn't
Cite to these 19 additional
We have
at any point in the record? Is it
yes,
anywhere in the record?
not
Where?
as identifying them individually. However, throughout these proceedings, at every single status conference, and in all of those motions, we have told the court that there are pervasive and ongoing substantial errors in a number of the transcripts, in at least, and when I say 19, Judge, I said I could talk about 19. I actually only can identify for you 9 for purposes today. 5 of them are entirely missing the FTRs. Another 5 there's a lot of errors. There's an error on every page, but they're what we would consider substantive. But
When you say things are entirely missing, you mean what?
The FTRs are gone.
Pages are?
No, the FTRs are gone.
The FTR is gone.
So there's no way to know whether or not the transcript's correct.
So you said that's 5?
That's 5.
And so there's 14 others. When you say 14 other, you mean 14 mistakes or 14 days where there are errors?
Judge,
do you
it's
mean?
our position that there are substantial errors in everything but a few. Okay, but when I say 14, I apologize. When I say 14, I'm saying that I had 9 examples for you prepared today to give you an example of what we thought was a substantive error.
Okay.
There are 5. I had 9 prepared today. There are 5 other ones that we've identified as having a lot of errors, but they're not what we would call substantive errors.
Okay, on the 9, are there errors like a sentence is wrong, or, I mean, you're saying there are 9 days with errors, or 9 sentences with errors, or what?
9 days.
9 days with some major error.
Correct. That
In-
change the meaning.
Okay. I'm focused on the materiality of this issue and where we are under Rule 32. The voluntariness hearing was retranscribed.
Correct.
Given that the confession was upheld, what of the errors that you've identified are really material to a Rule 32 at this point?
First of all, Judge, it's our position that we don't have to establish materiality at this point. But under United States versus Whedon, the recent decision out of the Ninth Circuit, I think it's 863 F. 3rd. I think, I apologize, I have it. But under that, it talks about how counsel is ineffective if counsel makes a decision about strategy before they do their investigation. In our perspective, imagine our role as PCR lawyers. We have to look at a transcript, and we have to look at an FTR. And so under Rule 31, under Rule 30, we use the word certified court reporter. We used authorized transcriber. Those are the only items that are actually legitimately filed in a capital case. In fact, I think it's Rule 31. I apologize. It's Rule 30. No transcripts of the proceedings shall be considered official except those made from the record certified the reporter or other authorized transcriber. So our dilemma, we have the burden of proof in Rule 32.
Right, but go with me a little bit on this issue. Assume, as I said, the voluntariness hearing has been retranscribed, and we have the confession. There's the issue of the closing argument. Have you identified substantial or material errors in the mitigation testimony?
Yes, Judge. That's what I'm telling you, that we have found it in the examples I brought for you today were just examples. Potts is an important example. There are a number of these examples.
In the mitigation section?
In the mitigation section, in the trial section, in the opening, in the closings. I apologize.
You need to help us. You're making broad arguments, but you should tell that we are very focused on specifics.
Right.
So what substantial errors have you identified in the mitigation section of the trial?
Okay. If I may, I'll use the September 13 of Dr. Potts.
Okay.
Okay. With respect to the Dr. Potts, that's actually a very confusing transcript because at one point it was corrected and it's hard to tell. The newer ones aren't certified. But with respect to Dr. Potts, his testimony is there are portions of it that are omitted. There are portions of it that are changed, and he was the main expert. He's the September 13, 2004. The reason we didn't include that in our actual motions is because of the confusion of the 2 transcripts that are in the record. Judge, if I may,
Counsel, let me ask you, before you get to your point, what specific relief are you seeking from this?
Judge, we're just asking
court?
We're just asking the court for the funding to have a transcript of the FTR. We want an accurate portrayal of what happened at the trial, not what a court reporter's determination of what happened at the trial. I mean, the whole purpose of Rule 30 is accuracy and consistency.
Let me just ask a clarifying point. You are seeking funding for the transcript of the FTR for the entire trial, For something more than that? For something less than
For the entire trial, Judge.
Okay, but not pretrial, anything like that?
Absolutely not, Judge.
Okay.
And I think the rules and the statute advise that the court does not have to create a transcript for proceedings that don't affect the ultimate result of the case. Specifically, and let me explain why we've picked the entire trial. As Rule 32, it's our burden. At one point, we have clear and convincing. Another point, we have preponderance of the evidence. We have to establish our facts. So imagine our petition as we write it, and this is the frustration of why we continue to raise the issue. We write a petition, and we have to cite to a transcript, and we say, well, the official transcript says this, but the FTR says that. And so we're in a battle with the state at every single level, at the Superior Court, at any appellate court, and any federal court. We're in a battle over what are the actual facts that occurred at the trial. And when I say facts, of course, I mean the real, accurate, substantive facts. And so as we create our proof and we put together our petition, or we go through our evidentiary hearing and we put together our evidence, then we're in a battle over, well, you say this, but the transcript doesn't say that. And
What would preclude you, and as I understand your petition, you're seeking and recognizing transcripts are never perfect.
absolutely.
You're seeking a new transcription of the entire trial.
Okay.
So if I hear you right.
Yes.
So that you can file a petition.
Right.
And you are claiming, you're asserting you need that new transcription before you can file your petition.
That's our position. And having said that, Judge, we were, as you could tell from the the February 21st, 2007 hearing, we were amenable to portions, to
Right.
even having a conversation with Judge McCoy. Well, let's start here. We were amenable to that, but we never got the opportunity to go back in front of Judge McCoy and talk about that after he accepted our assertions at that time. We're still amenable to that.
What would preclude you from filing a petition on the current transcript, but appending to it, where there are material or major errors, as you assert, a declaration saying, although the transcript says this, a careful reading of the FTR says this, and it matters because, and then, include that in your petition?
Your Honor, it's no mystery that our big issue is trial IAC, the trial attorney. And as we go through that, we have a page limit. We have the proof, and if you look at Rule 30, Rule 31, you talk about what our requirements are for proof. There is a difference for proof of a certified transcript, which is recognized, and as I just quoted you from Rule 30, recognized as a transcript of the record versus attaching it to a petition. And that is why, and I want to reserve the rest of my time, but really quickly I want to say, our motion to substitute transcript was inartfully worded. What we were really seeking there was a recognition by the respondent that this was an official certified transcript to go into the record. So when we said motion to substitute, obviously we know that he doesn't have the authority to yank back the transcripts that the Supreme Court used, or that you do. But instead, what we were looking for was that to be filed in the record as a certified record by a court reporter so that we could use it as part of our proof. And that's what we're seeking ultimately with the FTRs, is legitimate certified transcripts that satisfy the rules that we can use as part of our proof. Thank you.
May it please the court, opposing counsel. My name is Miles Braccio on behalf of the Arizona Attorney General's Office, representing the real party in interest in this matter. Let me briefly address some of the questions this court had for Ms. Brooks-Primera in this case. This has been my great frustration with this case. When I came onto it many years ago, it was, well, there are errors in the transcripts. Okay, show us the errors in the transcripts. Well, just take our word for it. And so this case has been a moving target regarding this transcript issue ever since I've been on it. And I think this court's questions to counsel are very good, which is, where have you cited us these errors in the transcripts? A lot of these errors have never been cited to Judge McCoy. I was pretty stunned to see the bolded words in the prosecutor's closing penalty phase arguments that had not been transcribed. That's the first time I've ever seen that. And it happens to be on a petition for special action to this court when we've been arguing about this transcript issue for many years down in the post-conviction relief court. Now I hear today that we have 9 additional errors or 14 additional errors or 20-some errors. I can't respond to that. They say take our avowals that these transcripts are in error, but they also made the avowal that the transcripts were materially erroneous in the voluntariness hearing, and they're not materially different. There was nothing in that transcript that was materially different. I caught names of like a case name, EVAC versus ESLAC, the tense change from wave versus to wave. There was absolutely nothing different in that transcript.
Counsel, if I hear petitioner's counsel correct, the voluntariness hearing is sort of a dead letter at this point.
Sure.
We're really talking about the trial transcript.
Sure. And again, so this question is, did Judge McCoy abuse his discretion by not retranscribing this entire trial or retranscribing these portions of it when they showed him nothing to justify that extraordinary expenditure or that extraordinary delay in this case?
We ran out of time with the petitioner, but let me ask you the question. The request is to order funding. In a case like this, who pays for the transcription? I assume the county. Is that right?
I can't answer those questions, Your Honor. I have no idea how the funding works. I know that they've had a conflict with OPDS. Mr. Velazquez sued OPDS during the course of this litigation, creating a conflict. I have no idea how that funding works. I've done the best to step in to at least defend what Judge McCoy did on the record that they've presented, unsealing all these hearings. But I think that's as far as I can go under the law and what I can speak to in terms of the funding for that.
I've also heard that a reference to a reference to a 40-day trial.
Correct.
Do you know, is that 40 days including the penalty phase?
I believe it is not including the penalty phase. Right. This is a very voluminous trial. I don't know. I would want to be very, very sure about that. But this is a very voluminous trial.
Counsel, I assume the state has an interest in having materially accurate transcripts from trials. Is that fair?
Absolutely.
The closing examples that we have seen suggest that at least arguably that wasn't the case here. Would you agree?
I would agree for that portion that they've cited. I'm bothered by it.
And that's really all I'm talking about. And then the follow to that is, what's the remedy for that?
There is no remedy. There's none that I see that this court can order. Let me just cut to the chase of what this case is really about, which is, does he have the full record to raise any of his claims for his post-conviction relief petition? We've been pending in this case for 8 years. It's actually 10 years next month. 8 years we've been arguing this case. Does he have the full record? And I thought Ms. Brooks-Premier did a great job of explaining the FTRs. I was going to do the same. Those are a verbatim video recording of every second of the trial. So he has the full record. So he tries to portray himself as saying, well, I don't have the accurate transcripts and I can't make my arguments from this record. No, he has the whole record. He has all of the transcripts, which all I know is they've only showed 2 errors to Judge McCoy below, and that's what I've attempted to respond to. I don't know whether the rest of the trial is materially erroneous. We can't say, well, we've looked at these errors from this penalty phase closing argument and then speculated that the entire trial is incorrect. And on that basis, we'd like Judge McCoy to retranscribe the whole trial. And of course, there are additional criminal rules that are going to apply that are going to prevent this, or at least, you know, we have a certified record under Rule 31.8, and I'm going to get to that in a moment here. But getting back to that point, he has all the record he needs to make any of his claims in the post-conviction relief petition. So if he says, well, the transcripts are in error here, he can go to the FTR and understand exactly what was said verbatim. He can make any of those arguments. He can attach it as an appendix, just as you suggested, Judge Thumma.
And let me follow up on that.
Sure.
I could understand, and that was my question I wanted to press with you. If that happens, let me assume 2 things. That the state might differ on what word was specifically used, in other words, construing the FTR.
Sure.
But from what you've said, that the state wouldn't somehow claim that submitting that form of declaration was improper.
Absolutely not. Absolutely not. In fact, I mean, technology is pretty good. We can splice off a portion of the testimony or the argument. Assume, for the sake of argument, that the prosecutor said something that amounted to prosecutorial misconduct and that was omitted from this closing argument. They can splice a portion of that argument and attach it as an appendix to their petition. I'm going to respond to that. I take that very seriously. I would never be in a position to say, oh, no, the transcripts are the certified record and we're not going to deviate from that.
So under that scenario, I'm just trying to play this through, what we're actually talking about here in terms of relief. There are different levels of proof. I think a petitioner could attach a declaration of a law clerk.
Yes.
I've watched the FTR as I read the transcript, and these are the errors. It could attach the declaration of a pricier lawyer. It could attach the declaration of a court reporter that it is paid to reproduce a certified transcript. So are we really, is this all just about who's going to pay for it? Is that all this is about?
To me, I guess I look at it more in terms of it's not who's going to pay for it, it's the form versus the substance. So the substance is they have the entire record. They have the video recording of the trial, and we're attempting to find out exactly what FTRs are missing. I think there's only a few, so we're in the process of running those down as well. But they have the whole record to make any of these claims. So, you know, I constantly hear, well, you know, it's the funding and it's the funding and it's the funding. If you sat down for a month, you could sit down and review all these and transcribe it yourself or identify any errors.
We don't want to pay a lawyer to do that. I mean, it'd be cheaper to have a court reporter do it, right?
Although if we've been arguing this issue they've identified it 12 years ago. At some point, don't you just say, I'm going to get the work done? Don't you just say, hey, I'm going to sit down and identify the errors and here's the basis for my claims? So maybe it is a funding issue, you know, and I certainly can't speak to that other than what I've said. But I look at it as a form versus substance issue. They have the whole record here. They have the video recordings of the entire trial. There's nothing warranting this court's extraordinary intervention with special action jurisdiction to resolve this issue. They have everything that they need to make their claims in post-conviction relief. I see this issue as intentional delay, continued intentional delay. Let me briefly talk about the rules that I've cited in my response brief as well. We have a rule to correct erroneous transcripts. That rule is 31.8G. While we've been arguing this issue below in the post-conviction relief court, that rule was 31.8H before the restyling of the criminal rules. And that's where this materiality standard comes from. So under Arizona law and State versus Shackert, we recognize that transcripts don't have to be perfect. And Shackert even identified certain erroneous parts of the transcripts, like you can have typographical errors, you can have garbled words, you could have whole omissions. So there's a real question about the materiality and whether they can even meet that. But that has to occur on direct appeal once the record has been certified and an appellate court sits and reviews the case. That's the end of it, because that court's reviewing it on that record. And I cited to this court State versus Esquire, State versus Davis, State versus Lopez. You can't go back and redo that transcript. Now, of course, they may have arguments here. Counsel was ineffective on appeal for failing to review all the transcripts and find these material omissions. And if he had done his due diligence, he would have discovered that the prosecutor committed misconduct and it would have been reverted. He can make those arguments here. He has the whole record to do that. I also cited to this court the comment to Rule 31.8H, which I thought was really pertinent, which said this is intended to avoid delay. Here we are 10 years in post-conviction relief, and we're still arguing about the transcripts. That's exactly what this rule was intended to prevent. The same rules also apply for, again, it's a little bit of a moving target for me. Now I hear that, well, we said substitution of the record, and their position was below. We're attempting to substitute this transcript in the record for the one that's part of the certified record. That's what they argued to Judge McCoy. Those same rules apply. Once the record has been certified, that's the certified record. You can't change that. That's what the Arizona Supreme Court relied upon, yeah.
That's not... that's not the issue today,
Right.
thankfully.
I'll briefly touch on the due process argument. He cited Griffin, Draper, Mayor versus City of Chicago. All those cases stand for, in fact, I thought it was sort of ironic. Griffin doesn't even really support his position in terms of saying all you have to provide a defendant is either a transcript or some other sufficient record that he can even make his claims. But in any event, again, I go back to it. He's been given all the transcripts in the case. He's not documented any material errors or omissions. This is the first time we're seeing that block quote. And he has the verbatim recordings of the entire trial, the FTR. So he's got the full record. This by far satisfies any due process concerns.
Since he now has identified the significant errors and omissions in the closing argument, do you think that we should nevertheless deny, if we accept jurisdiction, do you think we should deny relief because he didn't offer Judge McCoy that same block quote?
Excellent question. Yes, of course. This court doesn't fault trial courts for evidence that they didn't present to the trial court to justify their position.
So then, at what point would that get reviewed? Talk about delays.
Right. I mean, again, I look at this as intentional delay. They have the full record. I can't believe I'm standing here still talking about the transcripts 2.5 years later. They have everything
But what
that they
I'm
need.
speaking of is to avoid further delay.
Yeah.
Why should we not allow that mistake to be the errors and omissions in the closing to be corrected in a certified transcript at this point?
Corrected how? I mean,
Well-
what would be the point of even having a certified transcript? You can't replace the official record.
Well, okay. I thought you just said, though, that the petitioner has many ways of bringing this before
Correct.
the court.
Correct.
Declaration, certified transcripts, whatever. That's what I'm talking about.
Right.
What's the harm? Why should the petitioner not be allowed to offer a certified transcript at this point that would show that the closing, that the official record of the closing contains substantial errors and omissions?
Okay, I guess to go back, those weren't the arguments that petitioner presented to Judge McCoy. But again, we go back to this issue of does it have to be a certified or non-certified? If they attach a copy of the FTR, which is what actually transpired at trial, and they can show these omissions, they've proven their claim. So the certified transcript, whatever that will get you, is unnecessary in this case. They can make all of their arguments. I can't contend with what the FTR says. It's a verbatim transcript. It's a verbatim recording of the trial.
Well, but we don't accept videos in the record.
Oh, I thought we've attached
Not-
videos previously
not very
before.
often.
Arizona Rules of Civil Appellate Procedure take a dim view of that. This is a pretty
We're
unique
kind of-
case.
Sure.
Let me ask you, though, as a follow-up to Judge Johnson's question, if it wasn't a question of court-authorized funding, I assume the state would be agnostic as to whether petitioner got a court reporter or a law clerk or a volunteer off the street or an attorney to do this certification. Is that fair?
Absolutely.
Okay. So in that respect, is it a little bit form over substance that brings us here? The request is for a certified court reporter to do some or all, depending on where we are, I guess, in the briefing. But and I hear you saying you would have no objection if that was tendered or if counsel's affidavit or otherwise, recognizing you'd preserve the right to say, well, no, we read that sentence somewhat differently based on the FTR.
Sure.
Is that fair?
Sure.
So why should the state oppose the request for a court reporter transcription as opposed to counsel, volunteer off the street, law clerk?
And again, I go back to the way that the posture of the special action, I think I step into the shoes a little bit with Judge McCoy and just defending whatever his ruling was in terms of the funding. And he denied them funding. He's given them funding for and I pointed this out in my response, in a lot of different ways. So he granted him 200 hours to sit and watch these videos and identify any errors in the transcripts. He's given them 2 full-time attorneys. He's given them a full-time investigator, a full-time paralegal. There are interns now with the Capital Representation Project reviewing these. You've given him an unbelievable amount of funding to accomplish this goal. And so he can attach the declaration. I would hope this would be an unusual situation. I would not oppose him attaching an FTR. Again, we just look at this.
But if you're agnostic as to funding, why does the state care whether it's a certified, whether the petitioner is able to offer a certified transcript or not?
Intentional delay. Delay.
Okay. Setting that aside for purposes of this next question.
Sure.
What effect to this issue should the court system's interest and obligation and responsibility to provide litigants with, in criminal cases, with correct and accurate transcripts, what effect does that interest and responsibility play here? Because that weighs on me.
Yeah. I think that's a fair concern, Your Honor. I really do. Again, just for purposes of this case, I've only seen the errors now in this special action proceeding, again, identifying these material omissions, or I don't even want to call them material. They're substantial omissions. We have yet to argue over their materiality. So I have to assume under the Arizona rules that these transcripts are accurate. Okay, they can contain typographical errors. They can contain omissions. State versus Shackert, that's the law. And he's argued extensively in his briefing below, well, he has a constitutional right to perfect transcripts. No, he doesn't. That's not the law. That's never been the law. But that's a legitimate concern. I don't know what standing I have as the state to tell the court to intervene. Certainly, I agree with him. I agree with Judge Thum at the outset of this. He should have accurate transcripts.
But I think what you're saying is that the court should ignore that and not intervene. That's what you're saying.
No, it's not. I think in this case he hasn't provided any evidence that he's been presenting these arguments to Judge McCoy. He hasn't established any error, particularly the type of error that would justify warranting this court to intervene in special action jurisdiction.
Would it be fair to say that because he has the FTR recording, as you pointed out earlier, this is an argument about the form in which he'd make that argument, excuse me, or the form in which this court would intervene to preserve as opposed to the substance itself?
Well, I'm sorry.
Excuse me, I'm sorry, I'm losing my voice. I understand your position to be that he already has this information, so it's not as though this court's duty to ensure that he has the information is somehow not met if we decline to intervene in this case.
Correct. He has the whole record. He has everything he needs to raise these claims. I can't say that enough. That's exactly right. He just wants a different form. He wants it in a different version when he has all the evidence he needs to make any of his claims.
Do you think that that in his petition for review, I mean, say he attaches declarations from someone who has read who has followed along the FTR, says these are the errors.
Yeah.
Is the state going to argue that that's insufficient evidence to show that there are omissions and errors in the transcript because it wasn't a certified court reporter who provided the evidence?
I certainly can't speak to how I'm going to argue. I can't speak to my positions in a vacuum like that. But as I indicated to Judge Thum, I will never, if I'm still the attorney when they finally filed the petition in this case, if I'm still here and I'm still responding to that, I would never contest an FTR. That's the verbatim recording of what actually happened at trial.
Well, okay, but given that we don't admit FTRs in the appellate record, how do you convert the FTR to something I can hold in my hand and read?
Sure. And, Your Honor, if I can respond, I see that I'm out of time. Again, I would never contest a sworn affidavit or a declaration laying out those particular errors from the transcripts. We will have the full set of FTRs in this case by that point. I can then verify for myself. I would never object to him attaching the FTRs to it. He can make any of those arguments. I can't envision a scenario such as Your Honors that in which I would object or call that insufficient evidence. If the prosecutor committed misconduct, we have as great an interest as he does in making sure that that argument is heard by a court and his case reversed if constitutional error is committed. I share with him those concerns, and we don't take that lightly. So I would never be in a position to argue that.
Okay.
For those reasons, we'd ask this court deny special action jurisdiction, and I'll continue to object to the delay in this case. Thank you, Your Honors.
Thank you.
Your Honors, with all due respect, with respect to the last point he made, this is exactly an occasion where the state is objecting. You have two officers of the court. Every time a lawyer files a pleading, we represent to the court that what we've set forth in that pleading is accurate. We have stated in the pretrial conferences, in our pleadings, again and again and again, that there is a pervasive problem throughout the transcripts with the substantive. The filings that we did with respect to the ex parte motion, the motion to reconsider, the motion for funding, all of those were clearly examples of some of those errors. So,
my recollection is that you made those avowals with regard to the voluntariness hearing, which was then retranscribed by a certified transcriptionist, and there was no material error found. Is that accurate?
First of all, I disagree that there was no material error, because in that case, the lawyers made certain stipulations as to the evidence, and those were omitted and they were attributed to the opposite lawyer. So that actually, we believe that while they were nuanced and subtle, they were material in that instance. But actually, if you look at our pleadings, all three of the separate pleadings, if you look at the arguments made on 221, we're very clear that we repeatedly say that this is a pervasive error. So we have essentially declared, such as a law clerk would, or such as an affidavit would, that there's a substantial problem throughout the transcripts. And the state is saying, it's not enough.
We will give you more time to respond to our questions if it takes more time.
Thank you.
But let me ask you, talk to us a little bit about the funding issue here, which I'm starting to think maybe what this is all about. If the state is saying the petitioner may offer evidence or may offer to may show that the original transcript contains errors and omissions by several different means, a declaration by any one of a number of people short of a certified transcript, what would prevent the petitioner from doing just that, using a law clerk or a lawyer to do that versus a court reporter, and what are the funding implications of that choice?
Well, first of all, that was my point, in that what we have done is we have essentially made that declaration. It's not been accepted.
What we're talking about here is a day by day, here are the mistakes for day one, day two.
And we tried that, Judge. And after Judge McCoy denied our motion to reconsider, we got funding from Jim Haas to have an intern, and these interns are law trained because they're here from Europe. They're English lawyers. So we had an intern go through these transcripts and do this and do the analysis exactly such as you're saying. And what happened is we got 100 hours. I believe I might have said 200, but actually it was 100 hours. And at the end of those 100 hours, we ended up with maybe 5 or 6 indications of what the actual problems were in the transcripts. And part of it was the learning curve, but a declaration from her, then we have to go back and find out if it's substantive, and we're all playing with a different transcript. It's our position, and with respect to the funding, if we were talking about a 2-day theft charge where somebody was just given a fine and we had incorrect transcripts, I don't think we would have even had a problem with the respondent. But it is a 44-day trial, and that does include the sentencing phase, just so you know. And as a 44-day trial, it's a capital trial. It's not Mr. Velazquez, a petitioner's fault that it takes a long time to send someone to death.
Would you have to seek court authorization for funding to do the sort of declaration that the state is positing? In other words, I'm trying to understand
I can
why Judge McCoy had to intervene at all on funding.
Here's why. As was mentioned, OPDS is the overall funding organization. And so when you want, and we've attached some of the ROFs to our petition as the appendices so you can see what one looks like. But, and I can't tell you, I apologize right now which one.
Okay.
But when a person wants funding, they fill out an ROF, they send it to the funding person. In our case, it was Jim Haas because of the OPDS conflict.
There's some issues with that. Okay.
Yes. Okay. So they then say, yes, you can have that, or no, you can't have that. And when they say, no, you can't have that, which happens on a regular basis, you go to the judge. And the judge, who is the person who technically authorizes them to do the funding under the statutes, the judge then makes a secondary determination of whether or not they should have denied it or not.
Could your office do the sort of law clerk or lawyer a declaration without seeking intervention from Judge McCoy to authorize to require funding for a certified transcript by court reporter?
We did that, Judge. That's how we ended up in front of Judge McCoy. We asked for the certified, and we actually got the authorization, and a year later, then suddenly they took it back.
I thought, let me follow up on that question. I thought Judge Johnson's question might have been somewhat different, although perhaps I misheard it. I apologize. Could you or your staff do that, the affidavit sort of option, not the official court report or transcript, but the affidavit option without approval by Jim Haas or without court intervention?
A member of the staff, no. A member of the staff has to have authorization. That's why we got the authorization for the interns. But could I do it? Certainly. If one wants to make the attorneys for Mr. Velazquez witnesses in the case, I certainly could do that. But as we've stated in our petition, as we've tried to explain, it takes $64,000 just to watch the transcripts for us and watch the FTRs. That doesn't talk about stopping it and comparing it to the transcript as we go along and then creating an affidavit.
And I understand that, but I would gather from your avowals you've already watched
done
it. Right.
We've spot checked, Judge, which is looking for substantial errors.
Thank you.
Yes. Really quickly, I want to talk about the fact that Mr. Braccio keeps saying this is the first time he's seen these things. The actual documents of the ex parte petition, the motion to reconsider, were attached to the motion for change of judge for bias raised by the state in their response.
I think what he's speaking of is the block quote from the closing argument.
And that block quote is in both of those documents.
It was in. Say that again. Where
the block quote with respect to Jeanette Gallagher from October the 10th
was found where?
Is in the original ex parte motion. It's in the motion.
It's
which is by
what
the way,
exhibit is it to that motion?
It's actually in the motion. It's in the body of the motion. The actual quote.
In the body of the motion. So there's okay.
Correct. It's also in the request to reinstate funding. And those documents were specifically unsealed by Judge Gates in the bias so that the state, because they were attached and they were ex parte. So all of those things are there. But just again, those are just examples. We're in a position right now where we as Mr. Velazquez lawyers have made certain representation regarding the majority of the trial. And the state says they're not going to object, but here we are. If I could just make a couple of points, because I know you asked me some questions and you said I would. Briefly, of course. It's important that we understand we're not asking to use. Ms. Skinner corrects me. It's not in the original motion.
I didn't see it.
But I know that we had talked about it with Judge McCoy, and I know it's in.
So where, if it's not in the original ex parte motion,
request
where is
to reinstate funding or motion to reconsider? I apologize, yes, but I know it is in the pleadings. That's where it came from, and I thought it was in the original pleading. But regardless, it has been available to Mr. Braccio previously, and we've talked about it numerous times. Judge, we're not asking this court.
If it's there, I'd like to know because I searched and I couldn't find it.
If I could just have a second.
Okay. ask her to file it later. If you're unable to respond right now, we would be happy to accept a filing.
That would be great. Thank you, Judge.
Later today or tomorrow on that.
I apologize. I can do that.
Thank you.
Judge, this is about funding. It's not about the stage right. They do not have standing. This is about whether or not we're able to prove as part of the petition and investigate Mr. Velazquez's claims. This is not there's never been any kind of delay. One of the reasons I attached the motions to extend the petition, while you don't need them for this issue, the delay argument made by the state, you can see how complex this case is. It's a very complex case. There have been issues with the files. There's been issues with the lawyers. Unfortunately, our investigator died in the middle. There is no one who is intentionally delaying this case, and we've been raising this issue with Judge McCoy for over a year now, and as we got closer to the petition, we realized we could not do it.
All right.
Thank you.
Thank you to both sets of lawyers for your argument and for your briefing. We'll take the matter under advisement, and we expect to see a filing from the petitioner either today or tomorrow, and we will issue a decision or order in due course.
Thank you, Judge.
We're adjourned now.